All right, we have two cases involving the same defendant, versus Kyle Robert Robinson. Case number 17 CR 167, 17 CR 205. President for the state of Madison, okay. We have defendant's attorney Dennis Kirk. Are you Kyle Robert Robinson?
Yes, sir.
Ms. Robinson was placed on control in case number 17 CR 167 for possession of heroin on April the 3rd, 2019. Then also in case number 17 CR 205 for aggravated possession of drugs. The court then received a notification on the 22nd of June alleging that Robinson had complied with those conditions. Two federal reports since November of 16, 2020, and then Rule 7, refusing a drug test at the Madison jail after the officer requested jail staff to come up. The defendant was notified of the violations and appointed Mr. Burke to represent him, and he sent him out of your hearing today. Now, Mr. Burke, we had an opportunity to review the allegations with the client.
I have, Your Honor, and give advice to him of his right to a hearing. He does wish to waive said hearing and admit to the violations that's filed on June 22nd.
Right. Mr. Robinson, you do have a right to have a hearing in this matter. There's one here. There's the state, the prosecutor would have to present evidence of witnesses that would satisfy the court's belief that you have finding that you have failed to comply. And right now, your attorney cross-examine those witnesses, ask them questions, try to figure out that to help your side of the case. You have the right to present testimony on your own behalf. All witnesses on your own behalf to testify for you. Although you're not, you can testify on your own behalf, you wish, but you're not required to do so. You don't against you in any way. Now, in the event that you are found to have violated these conditions, whether it be by your own admission or by a hearing in court finding that they have proven the allegations, one of three things can happen. I can continue to control under the same conditions previously ordered. I can continue with additional conditions that are appropriate, including extending the term of probation to up to 5 years. The third, most serious, is that I could vote for control, send you to prison for 12 months on each case and fine you $5,000, $2,500 on each case. So there could be a total of 24 months and $5,000 in fines. Do you understand all of that?
Yes, sir.
Has anyone promised you anything or threatened you in any way against you to admit to these violations?
No, sir.
All right. Do you have any questions at all about what the allegations are, what the possible consequences are if you admit to these allegations?
No, sir.
You understand?
Yes, sir.
All right. And do you admit or deny the allegations?
I admit.
All right. Anything for probation regarding disposition?
Thank you, Your Honor. Given that this is the defendant's first community control violation, clearly there's an ongoing substance abuse issue here. The State and Probation Department would ask that you continue on community control, possibly extended, and or be complete STAR.
Have you been in contact STAR yet?
No, Your Honor.
Mr. Kirk?
Thank you, Your Honor. I would ask the court to continue community control. Did speak with Ms. Sturgill. She does believe he could be a possible candidate for drug court. She would need to do a formal assessment to determine that. So we would be open to drug court as well. In regards to STAR, he's open to going to STAR. He was at STAR one other time, but because of his medical conditions, his leg is amputated, and he's facing potential of having the other leg amputated. Not sure if STAR would take him or not, so he's open to STAR as a possibility. He did indicate to me the reason for the relapse was the medical things. He was doing fine and then got the news that he might lose his other leg, and he reacted, as he now states to me, inappropriately and turned to the wrong means of coping with it. and so that's why we're here today. But would ask the court to continue community control and consider drug court or any other appropriate treatment. Thank you.
Mr. Robinson, anything that you would like to say?
Yes, sir. Just that I was doing good for close to 2 years, a year and a half to 2 years. Just checking in, paid off all my fines. It was just my first mess up, so and that's it.
How old are you?
35.
Are these your only felony convictions?
Yes, sir.
You're not in prison before.
No, sir.
What's your medical condition that's caused you to
Uh,
lost your leg?
I have spinal cord. I was in a bad car. I was a passenger in a car wreck and broke my back. So I'm paralyzed from the waist down. I don't feel nothing. And so it's like I get any kind of open wound or anything in it, just gets out of control really fast. That's why I have a big.
What's your current health condition with your other leg?
They're wanting to take it now. Yeah, I have ulcer the size of a $50 in the bottom of my foot. It's down to the bone. They've done 3 surgeries on it.
Yeah, yes, no. All right. Well, I'm going to continue under committee control with additional conditions. I'm going to extend your term by, let's see, 1 year. The time that you were not reporting is also told, so that's added to it. So the year plus the time that was told from the time the warrant was issued for you. Secondly, is that you complete residential treatment and aftercare. I'll refer you for evaluation of the drug court. At this point, I don't think that these candidates will star in contact. But with your health situation, I seriously doubt they're going to be able to take you in that program, particularly if you may have to go surgery. So I think another residential setting is probably more appropriate in aftercare. For the time being, you'll remain in jail until there's residential treatment available for you. And then at that time, you'll be released to them. Also be required to pay the court costs. Now, regarding drug court, you only have these 2 felonies. You've never been to prison, but you were originally assessed at a 15, which is moderate risk. And then you've had these relapse, plus you have a fairly extensive misdemeanor history. I'm not sure, I haven't looked at your report to see what your previous issues were with treatment. In any event, I'm not sure you'll meet the criteria, but consider it at least, given your health situation. And in the event that it, something that you want to do, what I'll explain to you is that I don't require people to go to drug court. They have to want to, they have to apply, because it will be more intensive, and there will be more involved than what you've been on your regular control. But its focus is on your sobriety, helping you maintain that sobriety and deal with other issues that might be a factor in your relapsing and taking drugs. So you'll be contacting Mr. Sturgis, talk with her, she'll plan for a fee. You think it's something you want to do, request admission, and then probably do a hearing. When Zoom just for me to go over with you to make sure you understand what it is you're doing, and you can talk to Mr. Sturgis about it. All right, so anything further from council?
Your Honor.
Thank you. Stephen Monty. All right, this is case number 19 CR 175, State of Ohio versus Stephen Earl Monty. And you are Stephen Earl Monty?
Yes, sir.
Mr. Monty was convicted of illegal conveyance of drugs used under the grounds of a specified governmental facility and was placed on as a third-degree felony. Was placed on control on January 24th of 2020. There was a notification then filed that you have failed to comply with the terms of that entry. That was filed actually yesterday morning. Today morning. And it alleges that you have violated Rule 2 that you failed to report since April 27th of this year. Rule 3 that you failed to keep informed of your residence, place, of employment at all times change without permission. And it alleges that on April 14th, without permission. Rule 15, you failed to make any payments toward your client's costs. And Rule 19A, that you failed to provide documentation including any aftercare that being evaluated for residential tree. Signed by Officer Kelly on the 28th and filed in court. Now, you do have a right to have a hearing on this matter, Mr. Monty, in which the state will have to present evidence and proof for satisfaction if you fail to comply with these conditions. You have a right to have a reasonable period of time to prepare for the hearing, usually that's about 10 to 14 days. You have a right to have any witnesses come into court to testify for you, just like the state. You have a right to have an attorney to represent you. You can't afford to hire one of the appointed to represent you at no cost. You have a right to have witnesses against you cross-examined either by you or your attorney represented by counsel. To try to bring out evidence to help your side of the case. You may testify on your own behalf, although you're not required to. You may not be forced to. If you don't testify, that's not used against you in any way. Now, in the event that the court finds that you have failed to comply, one of three things can happen. I terminate your community control and sentence you to prison for 36 months, $10,000. I could continue community control under the same conditions previously ordered, or I could continue with additional conditions I've been appropriate, which could extending it up to a total of 5 years, although I've only been on it for a little over a year at a time. Like the last couple of months, this one reporting would be told, meaning we didn't count. So that would be possible outcomes. Now, you do have a right to have an attorney to represent you, and if you can't afford to hire one, won't be appointed. So, do you wish to be represented by an attorney?
No, Your Honor.
You understand that if you don't have the funds to hire one, then I'll appoint one for you.
Yes, sir.
You understand that if you don't have an attorney to advise you, then you'll have to make your own decisions as to how you should respond to these allegations and basically conduct your own defense or advocate for yourself. You understand that? Has anyone promised you anything to get you to give up your right to have an attorney in this matter?
No, Your Honor.
Has anyone threatened you in any way to get you to do that?
No, Your Honor.
Well, if you wish to give up or waive your right to have an attorney, you'll need to sign a form that's be put in the file, confirm for the file that this is your decision. So I have a form over here, this kind of waiver, council waiver, legal sense, we can give up. And, there was a blank space which I filled in your name, so it would read, I, Stephen Romani, defendant herein, now, being now in open court, meaning it's open to the public, fully understand that the laws of the state, I have a right to legal representation. I do hereby affirmatively waive my right to be represented by counsel. Affirmatively means it's definite, but it's not implied, it's not something you're uncertain about, but it's definite what you want to do. Now, you can change your mind at any time, up to the point where if there's a finding that you have violated, and then I'm making my decision as to how to dispose of it. But anytime up to then, you can change your mind, and I have people do that all the time. No problem, and we'll just set the matter for hearing when the attorney's recommendation. Do you have any questions?
No.
Yeah. So is this, your decision is you want to waive, give up your right to have an attorney?
Yes.
I'm gonna have Dale do this meeting, take a look at that, if that's what you want to do, sign the form, and, you'll be giving up your right to have an attorney. All right, so is this your signature on the form by the X, Stephen E. Monty?
Yes.
Okay, well, you understand that this, means that you're giving up or waiving the right to have a court appoint an attorney to represent you in this matter.
Yes, sir.
Okay. Now, do you have any questions about the allegations, in the, notification, Mr. Molly?
No.
Okay.
Yes.
All right, well, the next step in the case then is, for you to either admit or deny. And that's kind of like pleading guilty or not guilty. So if you deny, you're saying that you, are denying that you violated or that you're refusing to admit it, you're wanting to have the state prove the case against you and to have a hearing. And then we would set the matter for hearing about 10 to 15 days for, both you and the state prepare for the hearing and submit witness. And then, the court makes a decision at that time whether or not to say through the violations. If you admit to the violation, basically you're saying, yes, I admit that what is alleged there is true, that I did that, those are violations of the court's order. And then again, that would mean that one of the three things I just explained to you could happen. I could continue to control the same conditions, continue with additional conditions, or third, most serious is I could revoke it and send you to prison for 29, 36 months. You understand that?
Yes, sir.
Have any questions?
No.
Okay. And then do you admit or deny the allegations?
Amen.
Okay, I did see this, police violation. Did the defendant go into residential treatment or was he just evaluated for outpatient?
Your Honor, the defendant did complete Ken's Waverly. When I spoke to him yesterday out of the jail, I did conduct a drug screening. It was positive. The defendant did advise me that he's homeless now. If the court would consider possibly sending him to start a program at this point, residential treatment, that would be our recommendation.
Okay. Molly, you have anything you'd like to say?
No, Your Honor. I mean, I'd like to pursue going to an outpatient though, because I never had a chance to go to outpatient. Because it cost me too much to go to the thrill, how much I get. I'd like to find a place to live.
I mean, how much you get, how much you're getting?
Well, I mean, just, it's a little too much. The thrill was 70 a session, which I couldn't afford 200 or something a week. So to follow up and go to the FRS, they would come and get me. First, because I never.
Well, I noticed that they indicated, at the time you were evaluated back in December 19, you qualified for residential treatment degree. And you said you would talk with your probation officer. You did test negative at that time. So you've not been in any residential treatment?
Outside here, no. They wouldn't take me at the Thrill, which is in my town, but I could get in there for that.
Well, my question was, have you ever been in any residential treatment? So the answer is no. Is that right?
In-house.
Residential, meaning in-house in this facility.
Yeah, in Kent's place.
You did go to Kent's place?
Yeah.
When was that?
Last summer, I think.
Did you complete it?
Yes, sir.
Oh, okay. Right. But then after you got out of there, it's when you did follow up on foundation. Okay. All right. What was the positive test for? All right, anything else you'd like to say, Mr. Monty?
No, Your Honor, that's basically it.
All right, well, I'm going to go ahead and continue on to control with some additional conditions. First of all, you're to be evaluated for a star, and if accepted the star, you'll be required to successfully complete that. If you're not able to complete the star, then you'll be complete another residential program. Residential treatment program. And aftercare, that's the big thing. You just follow up your aftercare. Let you to relapse, sure. And then secondly, you'll remain in jail until transported to residential, either to star or residential treatment. Pay the condition court cost. And this point, I will not extend your term. We'll leave it at 3 years because it's still a couple of years plus the time you for not reporting in April as added on to, so the last 2 months haven't counted. So we'll leave it the way it is at this point. All right. Do you have any questions, Mr. Monty?
No.
All right. Thank you. All right, Ronald Howland. All right, I have 2 cases here with the court involving the same defendant, Stephen Howe versus Ronald Howland Jr. You are Ronald Howland Jr. All right, in case number 20 CR 15, defendant was convicted of failure to care, a 4-3 felony. And then in 19 CR 209 was convicted of possession of heroin, 4-3 felony. Both cases is put under control and that was on February 2020, and it was accepted into drug court document at that time. Now, the probation officer, Barr, is present along with the drug court coordinator, Sturgeon. The court received a notification that from Mr. Carr yesterday, alleged that you violated Rule 2 in an on or after 6/8/21 you failed to report to the probation department. Rule 7 on 4/6/28/21 use fentanyl, methamphetamines, marijuana. And Rule 3/13, I'm sorry, is that 2 counts on or after 6/7/21 you failed to attend aftercare at Talbot House, and then count 2 that on or about 6/8/21 you left Clean Acres sober living house and never returned. And it was signed by Officer Carr yesterday. There's a signature over here that looks like Ron Allen. It doesn't have the date on it, and it has your current address there. And is you recall getting this yesterday, Mr. Allen?
Yes, sir.
Okay. All right, now, Mr. Allen, you have a right to have a hearing in this matter, in which the state and the prosecutor's office will have to prove these allegations for the satisfaction of the court through witnesses and testimony and evidence. You have a right to have an attorney to represent you to help you defend against those allegations, to cross-examine witnesses, to bring out evidence on your side of the case. And if you can't afford to hire an attorney, the court will appoint one for you. Now, you also have a right to have a reasonable period of time to prepare for that hearing, and that is usually about 10 to 14 days. It gives you time to consult with an attorney if you have one, to subpoena witnesses, and to prepare your case. Now, you're also permitted to testify on your own behalf, although you're not required to. You're not required to do so. And if you don't, it won't be used against you in any way. You have rights to subpoena witnesses to come to court on your behalf. Well, in the event that it's found that you have violated these conditions, I can do one of 3 things. I can continue community control, continue with the drug court with the same conditions, or I can continue additional conditions that I think are appropriate. Or the third, the most serious, is that I could terminate you from the drug court and terminate your community control and sentence you to prison for 18 months on each charge for a total of 46 months and fine you a total of $10,000. Now, do you understand the allegations?
Yes, sir.
And you understand the possible consequences?
Yes, sir.
Now, you do have a right to have an attorney, and if you can't afford to hire one, the court will appoint one for you at no cost. Now, I haven't received a financial disclosure form from you. Do you wish to have an attorney represent you?
Yes, sir.
You understand that if you can't afford to hire counsel, well, I'll appoint one for you, it won't cost you anything. And you understand that if you don't have an attorney, you'll have to make your own decisions as to how you should respond to these allegations, and you'll have to basically advocate for yourself. You understand that? Okay. Has anyone threatened you in any way or promised you anything in case you could give up the right to have an attorney?
Yes, sir.
This is your voluntary act,
Yes,
the decision. All right. I'll have to get one here that has to be signed and be put in the file for written confirmation that this was your decision in here in the court. Okay, so this is a form that has certain blanks I fill out, I put in your name, case numbers, or 2 of them, as we talked about, and then I fill in the blank form, and it reads then, I, Ronald Allen Jr., defendant herein, being now moved to court, fully understand that the laws of the state, and I have a right to legal representation, and I do hereby affirmatively waive my right to be represented by counsel. And so this is what we giving up your right, and affirmatively means you're definite, it's not uncertain or questionable, that you're definitely stating this is what you're going to do. So if you want to do that, I'll put an X next to the line that has dependent printed under it. If you sign this form, then you're saying that this is your decision, that you want to give up the right to have an attorney appointed by the court. Now, if you decide that after we've I've read this to you, after you read it, that you want to have an attorney, that's not a problem. No upset at all. This continues to matter for a couple of weeks to give you time to meet with your attorney to respond to the charges and be ready for your hearing. Now, do you have any questions?
Yes, sir.
And this is what you want to do?
Yes.
Okay. I'll have to mail, show you that form. If you want to give up the right to have an attorney, go ahead and sign it. If you want an attorney, don't sign it, just tell me, and then we'll set, get you an attorney so you can have a hearing. So is this your signature on that line next to the edge, Mr. Allen?
Yes, sir, Your Honor.
You understand signing after saying you want to give up the right to have an attorney?
Yes, sir, Your Honor.
All right. The court then will find that the defendant has waived his right to counsel. All right, now the next step in the process then, Mr. Allen, is you either deny or admit the allegations. A denial is kind of like a plea not guilty. It says basically, I'm denying that I've done this and I want to have a hearing for the state to prove the case. And as I said, you have the right to cross-examine your witnesses and to present testimony on your behalf. And you set about 10 to 14 days before you have the time to prepare and be a witness. Now, if you admit, that's kind of like saying you're guilty. Admission is that you're agreeing that what is alleged in this notification is true and that they are violations. And then that would subject you to one of the three things I indicated, which would be to continue under control and in the drug court, continue with additional conditions I think are appropriate, which could include extending the term, and also dropping the drug court, which I'm ready to control. Or the third, most serious, is like revoke your control, terminate your drug court program, and sentence you to prison. Each of the charges for 18 months consecutively for a total of 36 months and a fine of $10,000. Yeah, $10,000 fine. Do you understand all that, Mr. Allen?
Yes, sir.
Do you have any questions at all?
No, I don't.
So, do you admit or deny the
I
allegation?
admit it.
Right. All right. Well, Mr. Allen, I have to admit I was disappointed at what's happened, although I've been concerned about you for a while. I tell you that usually look like crap, and lost some weight, and you're not the same guy that was up in here in drug court. What happened?
Made the wrong decision, Your Honor.
Well, what led up to that? I know that.
Well,
That's evident.
Put myself in a bad situation around the wrong people.
Why did you leave New Hampshire? Why did you go to town?
Like I say, after I made that choice to be around those people and make that choice to pick up that drug, I had no longer had a choice. I mean,
Have you been arrested for anything?
No.
Never. So where were you staying?
Just, running around.
Different people?
Yeah. Out at Erskine's farm and just running with a lot of bad people.
So what do you think caused you to do that?
Making a decision on my own instead of listening to other people that wanted better for me. Like you guys,
Yeah, but you did so well for so long. I mean, surely you thought about what's, of course,
Oh, yeah,
you've only
I beat
been in
myself
custody for a
up.
couple of days and you're still probably,
Trust me, I'm sitting out there beating myself up.
sure, I understand that. But I mean, I'm trying to figure out, what was the stress or what was the trigger that caused you to do this? Tell me what you think.
I think a lot of it just my back working, and my back wouldn't let me do a lot of different things. I'm just gonna have to accept the fact that I'm no longer 20 years old. I can't work like that anymore. John told me that. He said, "Look, man, you're not 20 anymore, man. You can't work like that." I'm just gonna have to accept, what you can do. And I wish I would've stayed with that job down there at the recovery council. I loved it down there. You know, after I left down there, I didn't realize it till I left.
I kind of think that that was everybody's thought, that he didn't seem to be as happy and as well adjusted at Silver Acres, or Clean Acres, which is not a reflection on that, it's just a whole different environment for you, and, I kind of wondered if you regretted that you've done it. I know why you did it, you wanted to get a better job, make more money, but, yeah, that's not surprising to me.
Sometimes I get too big a hurry to pay stuff off, you know, like my fines and stuff. I just need to hang in there and pay it, you know, randomly as it comes.
So, you wanna stay in drug court?
Yeah, I'd like to.
Okay, well, Mr. Sturgill, Mr. Parr,
Your Honor, I do feel like he has really done great things in the past year. This is his first formal violation. I think it's probably going to take him a little while to figure out exactly what went wrong, but it definitely wasn't a good place for him, and we kind of saw that coming. He has been approved to accepted back to Recovery Council. They are willing to pick him up at 10 o'clock tomorrow, and I've made arrangements with Heather to get his belongings to him maybe later in the week.
okay, Mr. Parr, anything you want to add?
No, sir.
Recovery Council, you say?
Yes.
So, willing to go back there and
Yeah.
try to get back on the straight and narrow? Get back where
Would
you
like
were?
to. If opportunity to do that, you know.
Alright. Well, they should order the court then that the, that be continued on police patrol and drug court docket. That he be required to complete, successfully complete, TRC residential treatment program for substance use disorder and or mental health. And aftercare, and then he remain in custody until that's available, which would be tomorrow, you said. At which time he'll be conveyed there, paid the court costs. Okay, Mr. Allen, yeah, you did so well, but, you know, one of the things I was always concerned about, and I told you a few times, was that, yeah, you were in a hurry, you were impatient, like you said, and, probably a little overconfident. And I understand, and I'm saying this because now that I'm older, everybody kind of tell me I can talk about people's age. And I don't feel insulted because, you know, if you think you're insulted, then I'm insulted myself. But in any event, you know, if you're older and, you know, and you don't have as much life ahead of you as a lot of these other folks in drug court that are in their 20s and so I understand that, you know, thinking, well, you know, I've wasted a lot of my life, which you acknowledge you have, and that, you know, I really want to, you know, enjoy the rest of my life and being sober, and, you know, you just get too much to burn. You lose your focus, and, you know, you become impatient, and you just have to accept, you know, as I said to, you know, people before, and to you, the matter is that, you know, recovery is a journey, it's not a destination. You know, recovery is going to be, if you're committed to it, it's going to be something the rest of your life. If you're not committed to it, you know, the rest of your life is probably going to be a lot shorter than you want it, and what others that care for you want it to be. So, I think you can come back from this. You're not the first person that's relapsed. I'm glad that you were caught within a few days, because, you know, the longer it goes, the worse it gets for you. I'm glad that you didn't commit any other crimes. If you had, you know, then that'd probably be a different story. But at this point, it appears that you hurt no one but yourself. And I think that you, going back to recovery council, I'm impressed that they're willing to take you back. They were sorry to see you leave too. I think you were a real asset to the program. And I think had you stayed there, this would have had a different, you I think this will happen. Now, that's not to guarantee nobody ever relapses. I mean, people who work with them relapse too. It's just part of the disease, but it makes it a lot less likely. So, I want you to put this behind you and move forward with a positive attitude. I'm sure you're beating yourself up, but what you have to do is say, okay, I really screwed up, and take responsibility for it, moving forward, and not just let it define you, but let your recovery define you instead. So I hope that you can do it. I've always been very impressed with how far you've come, getting where you started, because if this is a handicap race, and people at the starting line, you were quarter mile behind, and you caught up, you passed a lot. So you did a good job. Now, you've had this setback. It's not the end, I don't think, for you. If you use it in a way to learn from it and move forward, just understand that, because you probably felt as good as you've ever felt in the last 20 years. Felt real good about it. And again, that's what you have to guard against. Confidence, losing focus, thinking too much about, the financial stuff and being successful. And the other thing you need to start thinking about is, once you do move on in life, is how much contact you're going to have in your home community. And, I'm not bad mouthing Greenville. I'm saying that, people that you hang out with from that area or surrounding area or anywhere that you hang out with, care where they're from, those people need to be no longer part of your life.
Yeah, exactly.
Because, it's not their fault you're relapsed, it's yours.
Oh,
But it puts you you put yourself in a bad situation, and the stressors and the triggers come back. And, I know we had the other day where we had somebody that said, I met a guy that I knew in prison, and he offered me a joint, I just grabbed it. He said he told me what prison name, and I immediately, picked up the joint. This was a drug court last Friday. And he ran, he forgot to think. Fortunately, it didn't go any further than that. But, that's part of what you have to struggle against every day for the rest of your life, because you have a lot longer prison record than you. And so, again, I have confidence that you can bounce back from this. You have the right attitude. And I hope that you are committed to this, because we're trying to, this isn't just about keeping you out of prison. I know you can do the time, you've done time before, and I can send you back and you can get in and do time, but, we'd be giving up on you, and I'm not ready to do that. And so, don't give up on yourself. You have anything else you say?
Sure, Your Honor.
All right. Good luck.
Thank you, Your Honor.
Please rise.